Hello everyone, welcome to another episode of Mind Map. Today's topic of discussion is intellectual property rights. First of all, we will discuss about intellectual property rights and its types, India and IPR, national IPR policy, issues in India's IPR regime and way forward. First of all, let's discuss what are intellectual property rights or IPR. Intellectual property rights or IPR are the rights given to persons over the creations of their minds. It may be anything ranging from inventions, literary and artistic works, symbols, names and images used in commerce, etc. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. The importance of intellectual property was first recognized in the Paris Convention for the Protection of Industrial Property 1883 and the Berne Convention for the Protection of Literary and Artistic Works 1886. Both treaties are administered by the World Intellectual Property Organization, that is WIPO. Different types of IPR are as follows. First is patents. A patent is an exclusive right granted for an invention. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. Next is copyright. Copyright is a legal term used to describe the rights that creators have over their literary and artistic works. Works covered by copyright range from books, music, paintings, sculpture and films to computer programs, databases, advertisements, maps, and technical drawings. Trademarks. It is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks date back to ancient times when artisans used to put their signature or mark on their products. Industrial designs. An industrial design constitutes the ornamental or aesthetic aspect of an article. A design may consist of three-dimensional features such as the shape or surface of an article, or of two-dimensional features such as patterns, lines, or color. Geographical indications. Geographical indications and appellations of origin are signs used on goods that have a specific geographical origin and possess qualities, a reputation or characteristics that are essentially attributable to that place of origin. Most commonly, a geographical indication includes the name of the place of origin of the goods. Trade secrets. Trade secrets are IP rights on confidential information which may be sold or licensed. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of the trade secret protection. Now let's discuss about India and IPR. India is a member of the World Trade Organization and committed to the Agreement on Trade-related Aspects of Intellectual Property, that is TRIPS Agreement. India is also a member of World Intellectual Property Organization, a body responsible for the promotion of the protection of intellectual property rights throughout the world. India is also a member of the following important WIPO-administered international treaties and conventions relating to IPRs. Budapest Treaty on the International Recognition of the Deposit of Microorganisms for the Purposes of Patent Procedure. Paris Convention for the Protection of Industrial Property. Convention establishing the World Intellectual Property Organization. Berne Convention for the Protection of Literary and Artistic Works. Patent Cooperation Treaty. Washington Treaty on Intellectual Property in respect of integrated circuits. Convention for the Protection of Producers of Phonograms against unauthorized duplication of their phonograms, and Marrakesh Treaty to facilitate access to published works by visually impaired persons and persons with print disabilities. Now let's have a look at National IPR Policy. The National Intellectual Property Rights or IPR Policy 2016 was adopted in May 2016 as a vision document to guide future development of IPRs in the country. Its clarion call is Creative India, Innovative India. It sets in place an institutional mechanism for implementation, monitoring, and review. It aims to incorporate and adapt global best practices to the Indian scenario. Department of Industrial Policy and Promotion, Ministry of Commerce, Government of India has been appointed as the nodal department to coordinate, guide and oversee the implementation and future development of IPRs in India. The Cell for IPR Promotion and Management, set up under the aegis of DIPP, is to be the single point of reference for implementation of the objectives of the national IPR policy. India's IPR regime is in compliance with the WTO's Agreement on Trade-Related Aspects of Intellectual Property Rights, that is TRIPS. Now let's discuss about issues in India's IPR regime. Section 3D of the Indian Patent Act 1970 as amended in 2005 does not allow patent to be granted to inventions involving new forms of a known substance unless it differs significantly in properties with regard to efficacy. This means that the Indian Patent Act does not allow overgreening of patents. Issue of compulsory licensing, that is CL. CL is problematic for foreign investors who bring technology as they are concerned about the misuse of CL to replicate their products. It has been impacting India-EU FTA negotiations. Data exclusivity. Foreign investors and MNCs allege that Indian law does not protect against unfair commercial use of test data or other data submitted to the government during the application for market approval of pharmaceutical or agrochemical products. For this, they demand a data exclusivity law. Enforcement of the Copyright Act is weak and piracy of copyrighted materials is widespread. Now lastly, let's discuss about the way forward. Promoting an environment of innovations in schools, the academic curricula needed to be rebooted. A proper resolution mechanism for resolving IPR-related issues is needed. India will be unable to take full advantage of the transformative benefits of a strong IP system unless and until it addresses gaps in its IP laws and regulations. Success of India's flagship programs, Make in India and Startup India, depends on the boost of innovation ecosystem with better IPR safeguarding. And more awareness is needed about the creation, protection and enforcement of IPRs to encourage the Indian industry not only to innovate but also to protect and enforce their innovations. Now it's time for the practice questions. First of all, prelims question. With reference to the National Intellectual Property Rights Policy, consider the following statements. 1. It reiterates India's commitment to the Doha Agenda and the TRIPS Agreement. 2. Department of Industrial Policy and Promotion is the nodal agency for regulating intellectual property rights in India. Which of the above statements is or are correct? 1 only, 2 only, both 1 and 2, or neither 1 nor 2? And now mains question. In a globalized world, intellectual property rights assume significance and are a source of litigation. Broadly distinguish between the terms copyrights, patents and trade secrets. So that's all for today. Stay tuned for the next episode. Thanks for watching.